Good morning. Happy Monday. I had someone complain to me that they didn't want to watch an hour-long plus video on why Chile was wrong. And yes, I am in my 1971 Ford F100. Oh, got it running. Oh, it's running like a top. I love it. Anyway, so the long and the short of what Chile was doing is he was trying to make an argument that the justices were operating from racism, that it was all racist, everything racism. And these racist judges didn't like black man Terry. And so all of a sudden we have stop and frisk. And that was his underlying like motif, as it were. And the problem is that it's the same justices who had so Terry was like 67, I think. I could be wrong on that. But Mapp versus Ohio was a black woman, and Mapp versus Ohio is where the Supreme Court held that the Fourth Amendment of the United States Constitution applied to the states, and so they had to have probable cause for arrests and search warrants. And Mapp versus Ohio, Mapp was a black woman, and the Supreme Court said, yeah, the Fourth Amendment applies to the states. So that's kind of hard to swallow, that these judges were racist against Terry, a black man, but they weren't racist against Mapp, a black woman. In addition, I'm going to say 1964, well, I know it was the Civil Rights Act of 1964, so it was like 64 or 65. There was another Supreme Court case, and I never remember the name of it. Some like hotel at the Heart of Atlanta, or the motel, Heart of Atlanta Motel, something like that, versus the United States, where the same Supreme Court, I believe it was the exact same justices in like 1964 or 65, like 2 or 3 years before they decided Terry v. Ohio, said that the Civil Rights Act was constitutional under the Commerce Clause, I think it was. And so it doesn't make any sense that these justices who said the Fourth Amendment applied to the states in a case that involved a black woman as the defendant, and said the Civil Rights Act of 1964 was constitutional a few years later, all of a sudden turn around and be like super racist. And again, you might notice that Thurgood Marshall, who is black, and Louis Sykes, who is black. Sykes was the prosecutor, the attorney for Terry, representing Terry at the Supreme Court level, and Thurgood Marshall is a Supreme Court justice. They didn't bring up racism. They weren't making any arguments about racism. So it seems to me that Chile is just inventing this racist theory whole cloth. Now, I did say several times in that video that it was Chicago, Illinois. It wasn't. It was Cleveland, Ohio. Dumb mistake. You know, that's what happens when you talk off the cuff without a script, which I always do, so I always make mistakes. But anyway, you get the point. That's a minor issue. Chile like to show clips from the end of segregation in the South, where white people in the South were complaining about desegregation. Ohio was never segregated. Cleveland, Ohio didn't have that kind of history of the South. So I don't understand, again, why Chile is assuming that Officer McFadden was automatically racist, why the Supreme Court was automatically racist. You know, I get that one of the justices, who was it? Hugo Black, had been a member of the KKK. Great, fine. That was then. But then he voted in favor of the Civil Rights Act being constitutional. I mean, that's not a very racist thing to do, unless I'm in Bizarro World, which I may be. To support his arguments, such as they were, he took the oral arguments that the attorneys made to the Supreme Court and used them to craft narrative. He cut them to try to make stories, to try to make narratives, and then he'd fill it in with, you know, what are you saying? What are you saying? What are you saying? What are you saying? As if questioning their motives somehow proves that the justices were racist. Now, you know, that's a totally rookie mistake. If you want to know the legal reasoning why the justices decided what they decided, then you look at the opinions. In Mapp versus Ohio, I think was every justice, there were no dissenting votes, and the Heart of Atlanta Motel, versus the United States, something like that. It's something like that. That was no dissenting votes. I think there were concurring opinions on it, but there were no dissenting votes. But if you read Terry versus Ohio, it's an 8-1 decision. I think there's 2 concurring votes on Terry. But if you look, so a concurring vote, by the way, for those of you who aren't aware of what it means, a concurring vote means that the justice thinks you got the right outcome. Oh, we agree with the outcome, but we don't think that you use the right legal reasoning to get there. We disagree with your legal reasoning to get there. That's what a concurring opinion means. Got the right outcome, but we don't like the legal reasoning you use to get there. So in Terry versus Ohio, I'm going to say it was Douglas. It wasn't Black. It was I think it was Douglas who, because Black was one of the, he joined in the majority decision. Anyway, I think it was Douglas. I'm going to go with Douglas. Wrote a dissenting opinion, which is the actual, if Chile had just read the dissenting opinion makes a lot of sense. The dissenting opinion says, look, we've held that the Fourth Amendment relies on probable cause. You can't search or seize without probable cause. This is what we've been holding forever. And now you're making a new standard where people can be searched and seized on reasonable suspicion. You're breaking apart the Fourth Amendment. You're dissociating it from probable cause, and that's a problem. So if Chile had just read the dissent, if he made a video where he was just reading the dissent, and this is why Terry versus Ohio was wrongly decided, he would have a good, solid legal reason as to why Terry v. Ohio was wrongly decided. But he's not smart enough to do that. He listened to the oral arguments, and he mistook the oral arguments for the actual reasoning of the court. Just so you guys are aware, there is there is an actual industry around people who listen to the oral arguments and try to read the tea leaves as to which way the court's going to go. And sometimes they're right, sometimes they're wrong, sometimes they're half right, sometimes they're not right at all. But you can't always determine the way the court's going to go based on the oral arguments. I mean, sometimes you can, but not always. And this is one of those cases where, especially if you don't understand what the court is saying and you don't understand when they're using hypotheticals, because it's an argument. You're saying, well, what happens if this? If the court does go with you, then what about in this situation? What's going to happen in this situation? And then the attorney's going to have to be like, well, in that hypothetical, this would be the outcome if you adopted my proposed strategy. And then the court would be like, well, is that a problem? Because what about in this situation? So you can't always, because the court might have its own way of resolving that particular issue by tweaking the language slightly or whatever. So you can't always determine the way the court's going to go or the reasoning it's going to use from the oral arguments. And it's just Chile's naivete. He doesn't understand the process. He doesn't understand what's going on. He doesn't understand the legal terminology enough to be able to follow what the justices and the attorneys are saying and arguing and the points that they're raising. He didn't even understand that the facts that they rely on were the facts that were developed at trial and the logical inferences that you could take from those facts. So the facts were developed at trial, and he's listening to this, and he's thinking that these attorneys are giving away facts and they're establishing new facts and blah blah blah. And these are the things that were established at trial. There's no new facts being raised at the Supreme Court level. I mean, it's just a day late and a dollar short if you try to bring in new facts at the Supreme Court level. So anyway, that's the nutshell. Under 10 minutes. Thank you for watching. Have a great day.